At first appearance, I'm going to inform you of the charge or charges pending against you. I will then determine whether or not there's probable cause for the charge. If I do find probable cause, we'll discuss what conditions, if any, are appropriate for your release. If I do not find probable cause, you'll be released on your own recognizance. Because these are criminal charges, you do have certain rights. You have the right to be represented by an attorney. If you cannot afford one will still be appointed by the court. You have the right to remain silent. Everything you say is being recorded and may be used against you. I do have the public defender present as well as the state attorney. Please announce your presence.
Jose Cabrera.
And
Mark Bishop from the public defender's office.
good afternoon to you both. And from the state attorney's office.
Jose Cabrera on behalf of the state.
Okay. All right. I do have a list of the folks who are in the different rooms. I'll call them in the order that was given to me. I've got Colin Gayadine, 21 CF 157. Good afternoon, sir. Can you hear me okay? All right, good afternoon. Sir, you're here for a charge of driving on a suspended license, third or subsequent offense. Would you like to have the public defender represent you today? All right, I'm going to appoint the public defender at this time. I have reviewed the probable cause affidavit as well as the driving record. It stated it does not appear that this is in fact a third or subsequent offense. In fact, there doesn't appear to be any prior convictions.
I agree, Your Honor. I also saw that on the driving record.
All right, so I do find probable cause for the misdemeanor offense. Now that being said, State, do you have a motion? Well, let me do this. Let me set bond in this case, but I'm going to do so in recognition of the fact that you have two pending suspended license cases right now, which is probably why that officer was confused about the number of cases. So bond in this case will be set at $2,000. And then State, do you have a motion at this time?
Your Honor, I don't know if bond was set in those cases or he was simply just, was bond set in those cases, Your Honor?
I believe it was in 21 CT 59. I can double check.
I believe that was a citation.
That was 21 CT 202. Was 59 also just citation?
The state doesn't have that information provided. I'd ask that it be considered.
I can look it up.
I'd ask that they're not asking to do anything with that case.
The court can do it on its own motion, pursuant to statute.
It's 21 CT 59.
Mm-hmm.
I did see, Your Honor, that it was set on first appearance, although I do not see a first appearance court order, so I don't know what ultimately happened with it as far as...
He was arrested. There was a booking sheet.
Okay.
There's no first appearance order, nor is there a bond information. But he was arrested and was released. Give me a moment. And just to clarify my position on this, 903.0471 says, notwithstanding 907.041, a court may, on its own motion, revoke pretrial release and order pretrial detention if the court finds probable cause to believe that the defendant committed a new crime while on pretrial release. So the question is whether or not Mr. Gaidin was on pretrial release.
And it doesn't show that he was on pretrial release.
Well, I mean,
Nothing to show or indicate he was on bond.
well, I said he was booked. How did he get out?
Well, we can't assume anything. There's nothing to show that there is a bondsman. There's nothing to indicate that. And I'd hate to see someone be held on no bond if the bond was revoked and he was never out on bond. So I'm asking, that, all due respect, we don't assume anything.
I'm not assuming anything, but I can see for a fact that he was arrested and brought to the county jail.
But if he was placed on any kind of pretrial release.
And then I can clearly see he was arrested, brought to the jail, and then was released. I know he was released because he got arrested again. So the question is, how did he get out of jail? And that's an important question, because the booking officer can ROR somebody on their own, and that might otherwise preclude the court.
In the bonds tab, it does say there's a $500 bond.
Where does it say that?
Are you in showcase? Or
There should be a tab on top that says bonds. Court dates, and it should say bonds and then court actions.
Let's see, court actions. Oh, bonds. Oh, there you go.
There it is.
All right, so there was a $500 bond posted. Oh,
Your Honor, I have an order sent to you.
okay. Okay. Oh, that's why.
Your Honor, I sent them to your JA. I don't know if the other ones I printed for today were successfully printed in the courtroom. I can print this one out as well.
Okay. All right, so oh, there we go. These from before. All right, so Mr. Gaidin, here's the deal. Because I did find probable cause that you committed the offense of driving while license suspended, I'm revoking your bond in 21 CT 59. And I'm doing this because this is the third case that you have accrued in the span of about a month on charges of driving on a suspended license. So, I wish you the best of luck, sir. All right. Ercildo Leon, 21 CT 256. Good afternoon, sir. So you're here for a charge of driving on a suspended license. Would you like to have the public defender appointed, sir? Can you hear me okay? Okay, would you like me to appoint the public defender at this time, sir? All right, public defender will be appointed. I have reviewed the probable cause affidavit. I do find probable cause. Now, what's interesting is in this case, there were multiple prior convictions, but it was charged as a misdemeanor. So,
Also noticed that, yeah.
so bond be set at the misdemeanor level. Bond be set at $2,000. Now, sir, I should point out, apparently you have a pending firearm license suspended in Miami as well. The court there may or may not decide to take action based upon this new arrest. Just heads up. Good luck to you, sir. Thomas Mattingly, 21 CF 159. Good afternoon, sir. So you're here for a charge of grand theft and a charge of, looks like, scheme to defraud. Would you like to have a public defender appointed at this time?
Yes, sir.
All right. Yes, ma'am.
Probable cause argument.
Go ahead.
No probable cause argument for count 1, but for count 2, fraud, there are no allegations that communicated with anyone to speak or fraud. There's nothing in the response to the affidavit that speaks or that element.
State, would you like to respond?
Yes, Your Honor. Jury instructions state defendant engaged in a scheme to defraud, and scheme to defraud is defined as systematic, ongoing coercive conduct with the intent to defraud one or more persons, or with the intent to obtain property from one or more persons by false or fraudulent pretenses, representations, or promises, or willful misrepresentations of future act. The state would argue that over time, taking money from the register as a employee would count as a scheme to defraud.
Subsection 4 of 817.034 says any person who engages in a scheme to defraud and obtains property thereby is guilty of organized fraud. Why on earth they put this under the Florida Communications Fraud Act, I couldn't tell you why they gave it that title, but it does cover scheme to defraud, which doesn't actually cover communications necessarily. I don't know why. So I do find probable cause on both counts. Bond on each count will be set at $5,000. You may not return to the 7-Eleven at 4704 Golden Gate Parkway in Naples, Florida. And State, do you have a request at this time?
Your Honor, I did ask the ASA from, I believe it's mental health court, whether or not we should issue a Whitman or a bond revocation, and she indicated we should not.
They do not want to seek a Whitman warrant.
No, it's a weird, situation.
Okay, all right, fair enough. For the record, it is the state's request that a Whitman warrant not be issued at this time, and the state, if it chooses to pursue a violation of probation, will go through DOC and issue its own warrant to be signed by Judge Martin.
Yes, Your Honor. I believe the reason also additionally was that I think the process has in its own way already been initiated, which is why.
Okay, fair enough. All right, Scott O'Donnell, 20 CF 1287. Good afternoon, sir. Sir, you're here because of an order to revoke your bond issued by Judge Foster, I believe, on the 2 counts of grand theft and possession of firearms. Do you already have an attorney representing you on that case?
Yes.
And who's your attorney, sir?
David Wilson, and I have Christian
White. Christian White. Yes, sir. All right.
Yes,
So
sir.
the public defender's office already represents you.
Yes, sir.
All right. Very good. Then I don't need to do a separate appointment. You're already appointed on this case. Yes, ma'am. Did you want to speak?
The only thing I was wanting to make sure there wasn't an additional charge how it was worded, it was criminal contempt. I wasn't sure if it was just revoking the bond. And
Yeah.
it was worded kind of weird, so I wasn't sure there was an additional charge. But as long as it's just revoking the
I don't-
bond, and
I don't believe there's any separate charge here. Do you, Mr. Cabrera? I think this is
No,
this is just
Your
an
Honor.
order to revoke bond that was granted by Judge Foster.
I mistakenly printed that out ahead of time and then realized afterwards. So please ignore the one that I had printed out.
Okay. All right. So we're all in agreement then. This is merely an order revoking bond in this case. There is no new charges being added. Is that correct?
Yes, Your Honor.
All right. Very good. All right, sir. So I do find probable cause for the arrest. Bond is set at no bond on both counts pursuant to Judge Foster's order. You can talk to Mr. White. You can talk to Mr. Wilson about addressing this matter with Judge Foster. Okay.
Okay, thank you.
All right. Good luck to you, sir. All right, and I think I've got one more. Winslow Taylor. Excuse me. Good afternoon, Mr. Taylor. All right. So you're here for a warrant for the charge of possession of cocaine and possession of controlled substance with intent within 1,000 feet of a school. But this warrant's from Lee County. Excuse me. My first question is, would you like to have the public defender's office represent you?
Yes.
The appoint public defender at this time. So state, I've got a little bit of a problem here. The warrant that was issued out of Lee County does not have a bond set on it. It just says to be set by first appearance judge. I'm the first appearance judge. I don't have a probable cause affidavit. I don't have any information about the case. So here's my issue. There's clearly probable cause because probable cause was already found by a judge and a warrant was issued. But what bonds should be set without any sort of facts provided to the courts?
Well, probable cause was found on possession of cocaine and possession of controlled substance. So I would argue the standard bonds for those, which would be 5,000.
No. One of the charges is a first-degree felony.
Oh.
Possession of controlled substance with intent within 1,000 feet of a school.
Gotcha.
Right? So once again, I think the facts are important.
Agreed.
This is a Lee County case, so I imagine you would have access to a probable cause affidavit.
I would, Your Honor. I will send that to you or print it out in court as quickly as I can.
Okay. And obviously, ma'am, I will give you a chance to review it as well. So here's what I'm going to do. I hate to make things difficult for you guys over there, but is it possible for me to go to the other room, address those cases, and come back to Mr. Taylor so his lawyer has a chance to read the probable cause affidavit as well as I do? Is that okay? All right. All right. Thank you. We'll be right back to you. Okay. All right. Thank you.
And Your Honor, I believe that minus the $5,000 bond.
I'm sure you would.
I'll give up the right to read it tonight.
No, I think I'd feel more comfortable if you had a chance to read it. All right. So we need to swear these folks in?
NJC, can you please have everyone stand and raise your right hand, please?
Pónganse de pie todos, levanten su mano derecha.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Juro o afirmo que el testimonio que dará a continuación representa la verdad, toda la verdad, nada más que la verdad, sí o yes.
Yes. Yes.
Thank you.
All right.
Today, who the refusal?
Everyone who's there, put your hands down. Please be seated.
Por favor, los que estén ahí todos, bajen la mano y siéntense.
You wanted the refusal sign?
Yes, please, I got cut you guys off early by accident.
That's okay. Shane and Hatcher both refused.
Okay.
Thank you so much. Stand by for the judge.
All right. So for everyone who's there, good afternoon.
Para todos los que están ahí, buenas tardes.
You're here for first appearance.
Se encuentran aquí para su primera comparecencia.
At first appearance, I'm going to inform you of the charge or charges pending against you.
Les informaré sobre el cargo, los cargos que se les han presentado.
I will then determine whether or not there's probable cause for those charges.
Entonces, determinaré si hay razones fundadas o no para su arresto.
If I find probable cause, we'll
Yes.
discuss what conditions, if any, are appropriate for your release.
Si encuentro que hay razones fundadas, entonces analizaríamos cuáles son las condiciones más propicias para su puesta en libertad.
If I do not find probable cause, you'll be released on your own recognizance.
Si no encuentro razones fundadas, serían puestos en libertad bajo palabra.
Because these are criminal charges, you do have certain rights.
Porque estos son cargos criminales, ustedes tienen ciertos derechos.
You have the right to be represented by an attorney.
Tienen derecho a estar representados por un abogado.
Even if you cannot afford one will be appointed if you ask.
Aún si no puede superar los gastos de uno, se les nombraría uno de oficio.
You have the right to remain silent.
Tienen derecho a permanecer en silencio.
Everything you say is being recorded and may be used against you.
Todo lo que ustedes digan se usaría y se podría usar en su contra.
So I just want to make sure you had a chance to speak with these folks before I came in, just because I know they didn't get sworn. So did you have a chance to talk to everybody beforehand? Very good. Thank you, ma'am.
Quería saber si usted tuvo la oportunidad de hablar con esta persona antes de venir acá. Si su señoría lo hiciera. Está bien.
And I didn't get a chance to tell you this the other day, Ms. Woodley. I probably should have done it before now. In the past, you or one of your colleagues would actually be in the jail with these folks. And if they started saying things that were detrimental to their case, you could hit a mute button. Since you no longer have that ability, you won't insult me if you jump out of your seat to address your clients if you deem it necessary at any point in time. And I will make sure that everyone else stops talking while you do that.
I didn't know where the cameras were.
You're gonna have to kind of come up here. So if you jump out and start running towards me, these guys are instructed not to tackle you. It's okay. You can talk to your clients and we'll all wait.
So the record knows about it.
That's right. I should have told you at the beginning, but I want to make sure you understand it because it really puts you at a disadvantage to not be able to hit that mute button. All right. So with that being said, Deanna Dudley, 21 CT 255 and 21 CF 158. Is Ms. Dudley there? Very good. Good afternoon, ma'am. Ma'am, you're here for a charge of DUI and a charge of possession of controlled substance. Would you like to have the public defender's office represent you, ma'am?
Yes, please, Your Honor.
I'm going to appoint the public defender at this time. I reviewed the probable cause affidavit, and Ms. Woodley, do you have an argument similar to the one you made yesterday with regards to the case out of the fourth DCA? All right. Mr. Guerrero, are you familiar with that case at this point?
I'm guessing it's an odor plus standard argument. I'm not immediately familiar.
Nope, a little bit different.
Okay.
I haven't, I've perused a little further. I really haven't dug into it in detail, but the long and short of it is the fourth DCA indicated that unless the state can verify that the THC in the substance that was found is synthetic or is resin, that it can't go forward on a felony charge. It has to go forward only on a misdemeanor charge of possession of marijuana.
There's no way to tell the difference between synthetic and natural.
According to the chemist from the Broward Sheriff's Office Crime Lab. So, with that being said, we have a similar situation here where this was a liquid oil-like substance in a cartridge in count 2. Given that there's no more information in the probable cause affidavit at this time, I would find PC for the misdemeanor based upon that case. And I also do find PC for the DUI. All right. Now, that being said, I did take note, ma'am, of the fact that you don't seem to be local. Although there is a, I have a Naples address for you, but you had a Michigan license. And I had a chance to take a look at this lady's criminal history, and there's 2 prior reckless convictions, reckless driving convictions. So state, do you have any position on bond or conditions of release?
Yes, Your Honor. We'd be asking for a heightened bond of $5,000 on the DUI, and for the possession of controlled substance, $4,000, and then for DUI, trying to think, SoberLink would be a condition we'd ask for.
All right. Woodley?
Oh wait, it's my apologies, Your Honor.
I don't think the allegation is for alcohol.
It's not alcohol, Your Honor. My apologies.
Okay.
And
It says, well, it does say I was able to smell the odor of an alcoholic beverage. It did say that, but. All right, but please continue, ma'am. I'm sorry. Go ahead.
What I was gonna ask for instead is, I'm fine with a slightly heightened bond, but as far as, the criminal history, it does stand out. It's limited in, the sense that it's a limited criminal history and nothing. So I'd ask that. I believe there's only one reckless, based on my search, and I only searched against Florida.
The other one was from out of state. There was a DUI arrest that resulted in a reckless within the state of Florida. And there was another reckless conviction in another state. So I know you don't have the advantage of the NCIC, the state not yet.
So I'd ask for count one to be, 2,500 and then count two to be 2,500.
All right.
A little bit of it.
Okay. All right. Bond on count one will be $5,000. Bond on count two will be $2,000. I'm declining to issue the sober link at this time. Just for what I said, because it doesn't seem to be the primary issue in this matter.
Completely understandable, Your Honor.
All right. Good luck to you, man. Take care. Let's just paperwork for that recall. Ah, perfect. Thank you. Did you get a copy? Or do I only have the only copy?
I did print 2 copies.
It's all right. I'll read it fast and we'll give it to Miss Woodley.
Okay.
All right, but let's finish up in this room, okay? I've got Colin Miles, 21CF160. Good afternoon, sir. So you're here for a charge of possession of marijuana more than 20 grams and a charge of possession of paraphernalia. Did you wish to have the public defender's office represent you, sir? All right. So that caused me to ask the question. I don't have a private attorney here with me today. Would you like to represent yourself? Would you like the public defender's office to help today? Or would you like me to continue this matter to tomorrow so you can try to hire a lawyer between now and then?
I can represent myself.
All right, fair enough. All right, I reviewed the probable cause affidavit. I do find probable cause on both counts. Bond on count one is $5,000. Bond on count two is $2,000. And State, do you have a motion at this time?
Yes, Your Honor. The state would be asking to revoke bond on 21 CF 55.
All right, so you do have a pending charge. Quite honestly, it's a very similar charge. And so I'm going to grant the state's motion in 21 CF 55 and revoke your bond in that case. Good luck to you, sir. Venancio Robles Martinez.
Venancio Robles Martínez.
Good afternoon, sir.
Buenas tardes, señor.
Sir, you're here on a warrant for a violation of probation.
Usted está aquí bajo una orden de arresto por violación de libertad supervisada.
And this is out of Lee County.
Esto es de condado Lee.
Would you like to have the public defender appointed to assist you, sir?
¿Le gustaría que un abogado de oficio se le nombrara para que le ayudara? May I speak?
Okay.
I was told I was going to be sent to Fort Myers.
Well, we're getting to that. My first question is, would you like a lawyer to help you?
Hacia allá vamos. Mi primera pregunta es que si usted necesita un abogado que le ayude. Okay, yes.
All right. I'm going to appoint a public defender at this time.
Le nombraremos uno en este momento.
Yes, ma'am.
Just looking at the teletype, this is from, I believe, back in 2017.
Mm-hmm.
And I understand that, looks like they were actually no bond out, but back in 2017, we were in a pandemic where transportation was very uncertain. And I know the county only has a certain number of people that everyone.
Estoy mirando de que este caso es del 2017.
This is a case from 2017.
Este es un caso del 2017.
And at that time, I knew it looked like there's 3 words signed, no bond.
En este caso, esta situación, West Hayward puso una fianza,
But at that time, we were transporting everyone.
pero en ese momento estaban transportando a todo el mundo.
Now based on the current pandemic,
Y en estos momentos, debido a la situación de la pandemia,
we can start to see what is transported
con la incertidumbre de quién o no está siendo transferido
and how old the warrant is.
y cuál es la mayoría de edad de esta orden de arresto,
I'd ask that the bond,
yo estoy solicitando que se le imponga una fianza,
Your Honor, the bond.
una fianza razonable, eso sería.
My understanding is that Lee County is picking up and transporting at this time, is that right?
That's correct.
Tengo entendido que Lee County, el condado Lee está recogiendo y transportando en estos momentos. ¿Es cierto esto? Sí, su señoría.
And frankly, even if I were to set a bond, given that he has another detainer, he won't be released either way.
De todas formas, como él tiene otra orden de detención, no se la pondrá en libertad, aunque le imponga la fianza.
Maybe, maybe not.
Puede que lo ayude,
So-
bueno, realmente, quizás y quizás no.
And I don't think we should put everybody from the front, unless that changes. From the last thing I was told that they only took certain, not everyone.
No creo que estén transportando todo el mundo semanalmente al condado.
I have a representative from the sheriff's office in the courtroom
Tengo un
Telling me-
representante de la oficina de la policía aquí en la sala
that the people who have holds, detainers, or warrants from Lee County are being transported.
y ha expresado que las personas que tienen orden de detención, orden de inmigración del condado de Lee hacia allá los están llevando.
If that information changes, obviously I would need to know.
Yes, Your Honor.
Si la información cambia, me gustaría saberlo. Sí, su señoría.
Okay. So I do find probable cause.
Encuentro que existen razones fundadas,
Bond will be set at no bond.
no tendrá fianza.
And sir, because the sheriff's office has informed me
Señor, debido a que la oficina de la policía me ha informado
that you do have an immigration detainer,
que usted tiene una orden de inmigración en su contra,
that I do need to put that, make that part of the court file at this time.
yo haré que esto forme parte de los archivos del tribunal en este momento.
All right, good luck to you, sir.
Buena suerte a usted, señor. Gracias, amigo.
All right, very good. Have a good day. Do we have anybody in the 215 who needed a Spanish interpreter?
Pardon?
Anybody in the 215 who needed an interpreter?
I have no idea.
I'll
I'll text him if he needs.
You have a 215 already?
I thought we had one set on 215.
Who doesn't see,
Oh, he's in Lee County? Okay,
we don't have it.
all right, never mind. No, we don't. All right, Andrew Strange. All right, good afternoon, Mr. Strange.
It's not Spanish.
Who's this? James Reed. All right, thank you. This is 21 CF 155. Good afternoon, sir. Sir, you're here for a charge of battery by person detained in jail. Would you like to have the public defender represent you in this case? I'm going to appoint the public defender at this time. I have reviewed the probable cause affidavit. I do find probable cause. Bond is set at $5,000. Good luck to you, sir. All right, what about Mr. Strange?
He's approaching, Your Honor.
Okay. All right, yeah, NJC, if you guys needed me to call anybody out of order like that, you just let me know.
Okay, Your Honor.
All right. All right, Mr. Strange, good afternoon. So you're here for a warrant out of Broward County. Did you want to have the public defender's office assist you in today's case?
No, sir.
All right. The warrant was for 1 count of dealing in stolen property, 1 count of false information to pawnbroker. I reviewed the probable cause affidavit. I do find probable cause. Bond is set at no bond. Are we transporting to Broward County right now? Ma'am?
I don't believe so.
Are we transporting to Broward County?
Your Honor, the county lets us know if they aren't, and then the hold's not placed. I would think that they are because we placed a hold on them.
Okay. All right.
Are you talking about transferring before the conclusion of the pending case that I have here, or on disposition at the same time?
On disposition. I just want to make sure.
Okay.
All right. Yep. No, you're going to take care of your case. You're going to take care of your case here first, and then go to Broward County.
And then I'll be transferred out.
Yes, sir.
That's fine. That is fine.
Yep.
All right. Yeah.
You too, sir. Take care.
Okay.
All right. Let me just go ahead and address the other two folks who were refusals. Kayla Shank, 21 CF 156, is here for charge of burglary of dwelling, a charge of grand theft, and a charge of possession of paraphernalia. Is she an actual refusal or is she a medical refusal? Anyone?
I'm not sure.
All right. I'm going to proceed in her absence so she has the opportunity to bond. Otherwise, I have to hold her. I review the probable cause affidavit. I do find probable cause on all counts. Bond is set at $10,000 count 1, $5,000 count 2. On 21 CF 156, you do not have any contact with the alleged victim or return to the scene where this is alleged to have occurred. And then on count 3, 21 MM 178, bond is set at $2,000. Lastly, Brock Hatcher, 21 CF 154. Same question, do we know if it's a medical or just actual refusal?
No, I'm not sure either. Sorry.
All right, I'm gonna do the same thing. I'm gonna proceed in his absence so he has the opportunity to bond if he wishes.
Should I make a probable cause argument?
On count 4,
Yeah.
I was gonna bring that up myself. Mr. Cabrera, I have a hesitation for probable cause on count 4. I don't know if there's evidence that Mr. Hatcher is the one who burglarized the structure. At least there's at least 3 or 4 days difference between when the structure was burglarized and when the item was found. I'm not sure recently possessed necessarily applies.
That was gonna be my argument, Your Honor.
Okay. Well, I don't find PC on that count. All right. So I do find probable cause for the grand theft, dealing stolen property, and resisting an officer without violence. Bond on count 1 is $5,000. Bond on count 2 is $10,000. Bond on count 3 is $2,000. And RWAR on count 4. Defendant may not have any contact with the alleged victim and may not return to the scene where this is alleged to have occurred. All right. Let me read this real fast. We can switch over and take care of the last challenge. there's multiple pages. Essentially, it's the same 2-page affidavit repeated multiple times, Ms. Woodley. You don't have to, just give me a heads up so you don't have to go to the whole packet, but. All right, Mr. Taylor, I'm letting your lawyer take a look at the facts that are alleged for this case, all right? No, it's actual sale. Yeah, it's not written correctly on here. You know, it's alleged sale within 1,000 feet of a park. All right. So, like I said, this is a warrant where a judge has already found probable cause. So I do find probable cause. Mr. Cabrera, after reviewing the facts, I don't see anything that is particularly aggravating about the facts or Mr. Taylor's criminal history that would require the court to set anything other than a scheduled bond for the 1st degree and the 3rd degree felonies. Does the state agree?
Your Honor, I did reach out to another ASA just to see what their sense was of it. Their recommendation was 75,000, but I understand where you're coming from, for sure.
Well,
yeah.
Well, make an argument if you feel that it should be higher.
I think typically, to be honest, Your Honor, when I asked, I originally thought this was near a school, not a park.
It's not a school.
Yeah.
Park is at the Lonnie Kai on spring break.
Right. So yeah, I think I do agree with Your Honor for the standard amount of 30,000.
All right, Ms. Woodley?
The only thing I'd like to add is even at 30,000, that would be high for someone who has a extremely limited criminal history of driving offense that was back in 2016. So I would ask for under $10,000 under the schedule based on limited history, and I always felt the threat from 5 years.
All right. Sir, where do you live?
Golden Gate.
You live in Golden Gate? I'm sorry? Golden Gate?
All
right.
Your Honor?
Yes, sir.
I would argue at least for the scheduled bond amount, based on the fact that he does have a FTA, I believe, in his history.
All right. All right. There are 2 counts. Count 1, bond will be set at 30,000. Bond count 2 will be at 5,000. All right, sir. If you can't post the bond, you will be transported up to Lee County. Okay.
Okay. When would that be?
Soon. I don't know. It's up to the Lee County Jail, the Lee County Sheriff's Office to make those arrangements. All right.
I'm gonna buy bond out.